Your condo association has a rule. No one with a felony conviction can live here. It seems straightforward. You want a safe community. But a federal court in Michigan found that policy could actually be illegal. If your association has any kind of criminal history restriction in your bylaws or rental policies, this is something you need to hear. Here's the assumption a lot of boards make. Our covenants are a private contract. We can set the rules for who lives here. And in many areas that's true. But the Fair Housing Act creates a layer of federal law that applies to community associations, and it reaches places most boards don't expect. A federal court case out of Michigan examined a housing community that had a flat across-the-board ban. No one with a felony conviction, period. No exceptions. No case-by-case review. No consideration of what the offense was or how long ago it happened. The court allowed the lawsuit to move forward not because a criminal history policy is automatically illegal, but because a blanket policy that treats every conviction the same way without any individualized consideration may create a different kind of legal problem. Disparate impact under the Fair Housing Act. That's a concept most board members have never heard of, and it completely changes how these policies have to be structured. Let me explain what disparate impact means and why it matters for your association. A disparate impact claim, even if a policy looks neutral on its face, even if it doesn't mention race or any protected class at all, if it disproportionately affects a protected group of people, it may still violate federal fair housing law. Because of documented racial disparities in arrest and incarceration rates across the country, a blanket ban on anyone with a felony conviction affects some groups far more than others, and courts have said that's enough, at the pleading stage at least, to let a lawsuit proceed. Now, this doesn't mean your association's powerless to address safety concerns. Courts have found that certain targeted restrictions like banning registered sex offenders can be enforceable because they're narrowly tied to a specific, demonstrable safety concern. There's actually a published case on that specific issue in Michigan. But narrowly tied to a specific safety concern is a very different standard than anyone with any felony ever. And getting that distinction wrong can expose your association to fair housing litigation. So where does this leave boards that genuinely want to protect their communities? The answer isn't to throw up your hands and say you can't do anything. It's to recognize that the structure of your policy matters enormously, and that policy written without careful legal thought is a liability sitting in your governing documents right now. What makes a policy more defensible? Individualized assessment. Considering the nature of the offense, considering how much time has passed, considering evidence of rehabilitation. Policies that account for those factors are in a fundamentally different legal position than a one-size-fits-all ban. And here's the piece that most boards miss entirely. HUD, the Federal Housing Authority, had issued guidelines on exactly this topic. Those guidelines were recently revoked. Does that make criminal history restrictions safer to use broadly now? Not necessarily. Courts have said they may still look to those guidelines as instructive even without them being official policy. The legal landscape here is genuinely unsettled, and that means the risk to associations hasn't gone away. This is exactly the kind of area where a board needs professional guidance, not just a policy copied from another community or found online. If your association has any kind of criminal history provision in your bylaws, your leasing rules, or your occupancy policies, it's worth having someone who understands fair housing law take a look before it becomes a problem. At ManageMax, we help boards understand where their governing documents may create exposure they didn't know was there. At ManageMax, we know that effective community management is built on transparency and systematic excellence. We provide full-service HOA and condominium management across Southeast Michigan, handling everything from accurate financial reporting to proactive maintenance. Our goal is to reduce the burden on your board while protecting your property values. If you're looking for a partner who values accountability as much as you do, visit us at managemaxproperties.com. Let's build a stronger community together.